My name is Rebecca Tester. I'm an immigration partner at Constantine Law, and I'm joined by my colleague and my fellow immigration partner, Alex Finch. Well, needless to say, it's been a very interesting time to be an immigration specialist, hasn't it? And we thought for this first podcast, we'll talk a little bit about our respective career journeys and then give a little bit of a brief overview of what's happened recently in the immigration world, touch on the Labour government's white paper, and some of the recent changes to the immigration rules. And then we're going to focus a little bit on one of the more controversial changes that have been outlined in the white paper regarding qualifying periods for permanent settlement, or ILR. So really, without further ado, I'll kick off with asking you, Alex, what was your pathway into immigration law?
Thanks very much, Rebecca. Well, I got my start in immigration in a high street legal aid practice. So I was dealing with asylum, deportation and human rights claims. That was in 2008. And I did seats in family, crime and litigation, but immigration was what drew me the most. And I got to start conducting hearings in the tribunal fairly quickly, and I did that throughout my 5 years in that practice. And also got to run country guidance cases in the High Court and Court of Appeals. I just really loved the exposure that it gave you to lots of opportunities to get involved in interesting things. And even having moved into business immigration, I really do appreciate the way that it's always changing, it's always politically relevant, and you always have to keep yourself updated. So I quite enjoy that. In 2012, an opportunity came up to move into the private sector out of legal aid, and I began work with a tech entrepreneur, Bruce Mennell, who's an amazing source of knowledge on British nationality law, and together we launched what was then an OASC regulated business advisor, which is still operating today. In 2015, an opportunity came up to move to Fragaman in the world of corporate immigration, so work permits, and I moved from a very small company to a very large global company. And there I found my way to the private client team, so dealing with investor visas, investment-based migration, entrepreneurs, as well as spouse visas, and during the Brexit process, applications based on EU law. So yeah, I've got to do quite a wide variety of things, and including running proceedings in SIAC, a Special Immigration Appeals Commission, as well as working on policy reform and drafting legislation. But launching this new department at Constantine Law is a really exciting opportunity, so I'm really, really looking forward to it. So that's all about me. But what was your pathway to where we are now?
Well, my pathway was a little bit different to yours, Alex. After completing my training contract at a mid-sized city international law firm, I was actually all set to become an employment lawyer. But instead, I ended up and I got the opportunity to start at Fragaman, one of the leading global immigration practices, as a newly qualified solicitor. So I think it's fair to say that me specialising in immigration was a happy accident for me, but it really ended up being one of the best career decisions I've ever made. I got the opportunity to work across lots of global immigration accounts, along with SME clients within a wide variety of sectors, as well as some private client work too. But I had a particular focus in helping the businesses within the financial and professional services sectors. I would say that was a little bit of my niche at the time. So then after just over a decade at Fragaman, I joined a national law firm to head up their immigration offering, and then subsequently joined Constantine Law to launch the immigration practice, reuniting you and I, Alex.
Yeah, brilliant. Yeah, okay. So now that our audience knows who we are and how we got here, shall we talk about the topic of the day? And when we were thinking about what we could talk about, I think there would really only be one conclusion as the first thing to talk about, which has got to be the proposals for earned settlement in the white paper. So, Rebecca, do you want to start off by giving a bit of a background on what was being talked about generally in that paper and what the specific proposals are there?
Sure. So back in May 2025, the Labour government introduced its white paper on immigration. Its clear aim was to restore control over the immigration system. So it outlines various proposals which will have the aim of significantly reducing net migration into the UK. Again, aims to kind of create a more controlled immigration system, like words like that are bandied around the white paper itself. But really the crux of it is that the UK government want employers to prioritise skills, training and development from within the domestic labour workforce rather than the reliance on overseas workers. So some of the key reforms contained within the white paper include tightening up certain work-related visa categories, strengthening compliance obligations for institutions that sponsor students to study here in the UK, doing some reforms to the family migration routes, and things like introducing English language testing across more visa categories. But it's important really to note that some of the changes within the white paper from May have already come into a force in respect of skilled workers. So back in July, we had a major statement of changes to the immigration rules, which have been in force since the 22nd of July. And what that did was increase the required skilled level for a skilled worker, reverting back to the pre-Brexit position of requiring the skill level to be at level 6, which basically means graduate level. So it doesn't mean a skilled worker applicant needs necessarily to hold a degree. It's just that the role that they're coming to do in the UK is deemed to be at that graduate level or above. Amongst other things, the skilled worker minimum salary threshold also increased, not as much as we thought it would, but it has increased to £41,700. But the reality is most occupations will require a higher salary, so it's a significant investment for businesses to sponsor workers under the skilled worker category. However, having said all of that, one of the most controversial changes that was mooted within the white paper was the proposal to increase the standard qualifying period for permanent settlement in the UK, otherwise known as indefinite leave to remain or ILR, primarily for work-related routes, from the 5 years it's currently to 10 years continuous residence. I guess it's important to note here that these proposals are in respect of those work-related categories. If you're in a category, one of the family routes, for example, so a spouse of a British national, we understand that the qualifying period will remain at 5 years for those categories. So we are really focusing on the work-related categories.
I was going to say, Rebecca, that if you exclude family migration and EU-based migration, which we know are not going to be affected, there isn't really much left other than work-related categories that lead to...
True, that is true. That's true. So, and so it's not just controversial kind of extending the qualifying period to 10 years. It's quite a long time. The proposed increase is widely understood to be applied retrospectively. So those already in the UK expecting to be able to qualify for ILR after 5 years could be facing 10 years. So that's proved quite controversial. So after that brief canter into what's happened over the last 12 months or so, what has the government specifically said, Alex, about these rules or this particular rule being retrospective?
Yeah, well, I have a sort of an axe to grind, I suppose, in a way on this, because as soon as the white paper came out, I published a blog the next day saying it won't be made retrospective. And then I think that very afternoon, Yvette Cooper, the then Home Secretary, was asked in Parliament about whether it would be retrospective, and she wouldn't confirm. And again, there was a debate in Parliament a couple of weeks ago at the beginning of September in which the Minister for Immigration wouldn't be drawn on this issue, essentially saying that everything is going to be left up to the consultation. Now, the reason I made that quite sort of confident prediction at the time was that there is a customary practice on the part of the Home Office that in general, when a change is made, it's made for people then entering the route after the change, and that the broad rules under which you enter the route will be honoured through to ILR. But that's a practice and not a law. So there actually could be a transitional provision put in place. So it could be that people who've already entered the UK on a pathway to permanent settlement can carry on and qualify in 5 years as they expected originally. But it could legally be that the government changes things retrospectively. Here, the legal position is not completely clear, but a lot of people have said since the May white paper came out that that there's a principle against retrospectivity in the HSMP litigation. I think that's not the case. Actually, what happened in 2006 is that the government extended the standard qualifying period for settlement from then 4 years to 5 years, and that change was retrospective for all visa categories. There was a class action lawsuit effectively by a group of HSMP visa holders, that then highly skilled migrant program class, and that legal challenge was accepted, was successful, but for very specific reasons. And where those reasons don't apply, and I don't think they apply here, I think a retrospective change is possible. There was a second example where this happened with Turkish business people who come in under the Ankara Agreement. So until 2018, they were able to qualify for ILR permanent residence after 4 years of residence in the UK. And in 2018, the government increased that from 4 years to 5 years with retrospective effect. And the Court of Appeal essentially held that that was legally permissible. There was no legitimate expectation on the part of a migrant who's entered the route on a pathway to permanent residence that the rules in place when they enter the route will be the rules in place until they obtain permanent residence. The reason that the HSMP challenge succeeded was because in that specific case, the government had made very specific assurances to that cohort in the guidance that changes would not be applied to them retrospectively and that they would be able to qualify for ILR after 4 years. But that's not generally the case. It wasn't the case with the Ankara Agreement example, and it's not the case, unfortunately, with skilled workers or other work categories now. And so I think the legal position, as far as the legitimate expectation is concerned, is that a retrospective change can be done. But whether they will do that is another question, because there's other considerations outside of the legality of the move, politically or from a perspective of making the UK attractive to global talent, as to why they might want to not do that. And I think it's fair to say that it might make the UK to some extent an outlier when it comes to permanent residence rights compared to other countries. Isn't that right, Rebecca?
Yeah, I think if or when the immigration rules adopt this 10-year qualifying period, it would be somewhat out of kilter with most other jurisdictions, but the UK won't be alone. I think the vast majority EU countries, for example, Australia and the like, the qualifying residence periods for permanent settlement are around 5 years, give or take. But quite notably, Japan has operated a 10-year qualifying period for some time for most people, but they do have the exceptions for very highly skilled migrants, or if you're married to a Japanese national. But really, I think what the question everybody really wants to know, Alex, is will these changes actually happen? What do you think? What's your prediction?
For me, I think that there's a few different questions there. One is, will the government really change the standard qualifying periods to 10 years? Yeah, I mean, there's a few different questions that one might be interested in. But I think that first question is, the answer is that they're going to do that. They said that they're going to do it in a white paper. That means that they're almost certainly going to do it. And the consultation is about how they're going to do it, not whether they're going to do it. But then there's two other questions as I think of it. One is, will they impose the change without a transitional provision, like what we're calling with retrospective effect? Mm-hmm. And then the other one is, okay, if they do have this 10-year standard qualifying period, how wide will the scope be to earn, as they say, on a points-based system, earlier settlement? Because within the ambit of the white paper, they say that they talk about the contributions that migrants make, and they want people who are contributing more to be rewarded. So there's the option or the possibility that they will reward certain cohorts with early settlement. Now, as far as the retrospective change is concerned, I've already made a prediction on this and I was wrong. So I kind of don't want to say. I still suspect that they won't do it, but I've been burned on that one before. On the subject of whether, how wide the scope will be, though, to earn back or earn early settlement, I think what I would say is that this is an area where we are looking at the domestic debate on immigration sort of spilling over or having a danger of spilling over into the structure of UK immigration system in a way that could have a serious impact. I think if you're thinking about the magnitude of a change that someone has made to move to the UK and become a temporary migrant, to double that length, is having a huge effect on them. And I've just listed out some of the effects here, and there may be others, but they've left a permanent job in their home country. They've left their wider family network behind. They may have sold a house back in their home country and bought a home here. They moved their family, their spouse will have changed jobs, their children will have changed schools, changed education systems, learned a new language, learned a new culture. And then while they're on a temporary visa, they're paying these very large visa fees, some of the largest fees in the world. They're restricted in the jobs that they can take. It's harder to start a business. They pay a high rate potentially for their mortgage. The children pay more for uni and they can't vote. So there are probably other effects that I hadn't thought of there. But to double these effects and to make them apply for a 10-year period really will be, I think, something that will decrease the attractiveness of the UK as a hub for talent, which it is. And we want it to remain that. So I hope that the provisions for earned settlement, if that's what it's going to be called, take account of those realities. But I think in this, as in many things, politics will have the final word.
No, I agree with you. I think, at first I've been a bit slightly on the fence on this, and actually will they even bring in the 10-year qualifying period? And I think, as you quite rightly said, Alex, they really have to, don't they? It's in the white paper, so it's going to be a case of what does it actually look like in practice. In terms of whether they'll make it retrospective, I'm going to stick my neck out. I don't think they will, but we can never say never, can we, Alex? So, in any event, like some of the proposals contained within the white paper will be subject to public consultation, I guess, as you said, and so we might end up with something watered down, if you want to put it in those terms, not implemented. Who knows? Let's watch this space, shall we, Alex?
Yeah, definitely. It's all to play for.
What timetable are we looking at for these changes?
Yeah, I took a quick look at the previous sort of major consultation, which was the 2022 new plan for immigration, if people remember, that preceded the Nationality and Borders Act 2022. That was launched as a consultation exercise, actually 2021, and it involved an online questionnaire, 21 engagement sessions, focus groups, and interviews with affected individuals and stakeholders. Mm-hmm. So from the time that was launched, you were given about 6 weeks to respond, and then the government responded to those responses around 6 to 8 weeks later with their decision on what they thought about the responses and what they were ultimately going to do. Mm-hmm. Now, I think actually it could be that quick, and there's political reasons why they might want to do it on a faster basis. 2021 to 22, the reason that took a long time was because that was primary legislation. But of course, to make this change, one would only need immigration rules, and the customary period is to give 21 days notice, and I think they would do that in this case. But it doesn't need to be any longer than that. So the consultation the government have said will be in autumn, which basically means Q3, Q4, right, before the end of December, potentially. But I'm guessing that they would want to wrap this up, wrap that up in the new year. And so we might potentially be looking at a statement of changes, I'm guessing, around about April 2026. So, 7 months from now.
Gosh.
So, that's kind of where we're going. That's where we think, what we think might happen and when it might happen. And I suppose the question arising from that, and why we're talking about this, is, well, what can you say if you're an employer of foreign national workers in the UK? What can you say to people? What can you do? How can you get involved?
I think first things, in terms of what employers can do to be kind of supporting their existing staff that could be affected by some of these changes, first things first really is anyone who's already clocked up 5 years in a qualifying category, get on and apply, right? So for example, a skilled worker who's amassed 5 years in the UK already would potentially be able to make an application for indefinite leave to remain, subject, of course, meeting all the other eligibility requirements. So encourage them to make an application. Unfortunately, for the ones that aren't in that position, I think it'll be advisable for employers, HR teams, anybody, any kind of key stakeholders responsible for hiring and the like. Stay informed of the changes. Be proactive in communicating with staff. It could be a really upsetting time or unsettling time for these people that really don't know what their status will be in the kind of medium term. As I say, monitor the legal changes, take advantage of any kind of resources out there to stay on top of the changes, and if in doubt, seek some specialist advice on it. With regards to more broadly the recent changes that have already come into effect from July, sensible for businesses to evaluate their recruitment and sponsorship strategies, ensuring the roles that are in the pipeline do meet these new thresholds, and be prepared to look at alternative visa routes if for example the skilled worker route doesn't work. Is there anything else you'd like to add there, Alex? I think I've covered it. I'm not sure.
I suppose, I suppose that when, and I think the government have said that there will be the opportunity to earn back early settlement, or I'm calling it earns back because I sort of think of it as something taken away. With the points-based contributions to early settlement, I think that's something that in future those managing global moves will want to have at the forefront of their minds.
Sure.
When they're planning moves to the UK, and will want to be, highlighting to people. So the sooner we get detail on that, the better, really. But I mean, as far as the importance of, firstly, hopefully not having these changes imposed retrospectively, and also the importance of having a way into earlier settlement that makes the UK continue to be attractive for global talent. I think that business needs to make a case to government if what they're hearing from people managing global moves is that if we're going to have to sponsor people for 10 years, it's going to be double the costs, it's going to be double the uncertainty, it's going to be no pathway into citizenship for their children. That's hurting the UK's standing as a place for skilled talent, then that's a serious point, and it needs to be brought to the attention of governments. And if it is powerfully in the consultation that's still to come, then I think everything is still to play for.
Great.
Brilliant. Okay, so that concludes the first of our immigration podcasts. I suppose it remains for me to thank everyone very much for listening. It's been a pleasure, and we hope that if you enjoyed this content, you will hit the subscribe button, and we look forward to the next episode.
Thanks
very
everyone.
much, Rebecca.
Bye-bye.